Yalavat everyone and welcome. My name is Rosalind Daya. I serve as a volunteer on multi-generational wealth management and protection, also known as MWMP, which is an initiative of Aga Khan Economic Planning Board for USA. I would like to welcome you all to today's webinar. And just to see who's joined us, there's an anonymous poll on your screen. Please take the poll. Before we begin, let me share the format for today's webinar. This webinar will last approximately 75 minutes. During this webinar, if you have any questions, we encourage all our listeners to submit questions via the question toolbox. We will spend the first few minutes listening to Chairman Akbar Poonawalla, who will share his thoughts on MWMP, followed by an estate planning and wealth protection presentation from Abdul Rasool and Andrea. We will finish up with next steps and Q&A. But before we start, I would like to convey that all the opinions shared today are for informational purposes only and do not include any kind of legal advice. You should consult an attorney to create an attorney-client relationship for them to help you. If you need any kind of advice, please always consult your professional advisor. With that, let me invite Akbar Poonawalla, Chairman, Aga Khan Economic Planning Board for United States. Welcome, Chairman Sahib.
Thank you very much, Rosamine. Yali Madat, everybody. It's a pleasure to be here with the entire US Jamaat and to be able to speak on one of the 6 strategic projects of the National Council for USA. I'd like to pick up from where President Saib Al-Karim Al-Dina left off in his introductory message over the last few days. He talked about the need for the importance of multi-generational wealth planning, whether it was the migratory pattern from Gujarat to Africa or other events that were guidance driven, education, the importance, the underlining of the education was so very important, and that has led to a number of positive outcomes for the Jamaat in businesses and in professions. Many of us, as President Saab had mentioned in his address, came here to the country, came here to the United States, to North America, with perhaps for an education, to get a good quality of life, to have a good future for our families. And mashallah, over the last 20, 30, 40 years that the Jamaat has settled in North America, the Jamaat has made significant progress. Similarly, the Imam also guided us on people of the same profession and the same occupation having to come together and to come together to help each other, to provide support to each other. And we've seen the formation of trade alliances, of many professional alliances in the Jamaat that have been able to help each other in downtimes, in times of need, in times of crises, for instance. And those associations have proven to be very helpful and important as well. So that was the second instance of how the Imam's guidance has guided us and set us on a certain trajectory. Similarly, for the last several years, we've been hearing from the Imam, amongst other messages, this one message about the Jamaat having to create a solid base for the future, to create the wealth that we have been able to create. It may not be huge sums of capital, it may be small pools of capital. Nonetheless, the guidance that we've been receiving is to be mindful, to be prudent in protecting, saving, and conveying the wealth for future generations. Probably we are in a challenging economic situation at the current point in time, but it won't be fully known until later. So we have to be protected, we have to be prepared to address those situations at all times. So these are some of the causes that we should take into account. But overall, there is also a tax reason, as the next part of the discussion will point to, and that is that given the amount of deficit that the US is faced with, but it is likely that the tax laws will be changed in the future, given the huge deficit situation that the country is faced with. Those are some of the reasons why we need to do this, and we don't know how future situations might evolve, economic situations might evolve. So I would like for us to pay particular attention to the discussion to ensue, and we have some experts who are going to talk about the multi-generational wealth management and planning in a certain context. They'll talk about the steps to take. And the idea today is not to just listen to the topic and go away and make a mental note of it, or perhaps not. So we hope that the Jamaat will benefit from it. This is a top priority for the Jamaat. It's one of the 6 strategic projects for the National Council of the United States. And this is something which is on the front burner. So I want to underline that. I want to emphasize that. And at the same time, I'd like to thank the Jamaat for participating, taking this subject very seriously. And it is very important that we build our futures by setting aside these resources for future generations and our families, as we've heard our Imam say. With that, I'd like to pass it on back to Rosemin and the team at Lyons Bernstein and Abdul Zindani. Thank you. Yali Madad.
Thank you, Chairman Saib, for sharing that inspirational message. Now, I would like to introduce our presenters. Abdul Rasul Zindani is an intellectual property lawyer with over 20 years of experience. Besides being a lifelong learner, he is passionate about giving back to our community and has served the Jamaat in several capacities. He has facilitated several estate planning seminars and comes with a wealth of knowledge. Welcome, Abdul. And along with Abdul, we have Andrea Kushner. Andrea Kushner, who is a director of wealth strategies with Lyons Bernstein, she has over 20 years of experience in wealth management and estate planning. Named as a Southern California Rising Star, as well as a super lawyer by Super Lawyer magazine. Andrea, we really appreciate you joining us today and would like to thank Lyons Bernstein for their support. With that, over to you, Abdul.
Let's get started. So we talk about estate planning and the purpose of estate planning. So why do you need an estate plan? Andrea, please help us understand, why do anybody need an estate plan?
Thank you, Abdul, and thank you for having me here today. Well, first, let's back up and talk about what an estate plan is. Abdul, you referenced this in terms of there, at times, is a little bit of a misunderstanding of what a will does versus an overall estate plan. An estate plan is a general term that we use to refer to the documents that an individual puts in place to manage his or her affairs in the event of incapacity and also in the event that that person passes away. So it includes naming individuals to handle your finances if you become incapacitated, also naming individuals or entities to handle the administration of your estate when you pass away, naming individuals to make medical decisions for you if you're not able to do that, naming guardians to take care of your minor children in the event that something happens to you when they're young. When you pass away, a solid estate plan determines who your beneficiaries are and when they inherit and the ways that they inherit. In other words, do they receive their inheritance all outright? Do they receive it in trust where it's distributed over time? And then, and this goes to some of the comments that the chairman made at the beginning of his remarks, which is also planning for the estate tax and potential changes to that. So an estate plan does a lot of things, and that's why it's so important. I would say that there are 3 main considerations with an estate plan and why you want to have one. One is that it provides you control over how your finances are taken care of and how things are distributed at your death. It gives you privacy to do that. We'll get into this later into our remarks, but if you don't have an estate plan, often what occurs is that a court, the probate court, determines how assets are distributed, and it's done by state statute. And that may reflect your intentions, but it may not. And then finally, by doing an integrated estate plan, you can do this privately, where you have the orderly administration of your affairs outside of a court process. It also, when done appropriately, it can save in costs to your family and delays in your beneficiaries receiving their inheritance. So for all of those reasons, it's really important to have an estate plan. And what is appropriate for you really depends on your family circumstances and the types of assets that you have. And so all the more reason that it's critical to engage with qualified counsel who can help you look through, the different options and determine what's right for you.
That's a great start. That's a good introduction. And so
Thank
let's
you.
say with that, let's get begin, right? So what we say, okay, we need a estate plan, and now we really need to understand what does it mean by having a multi-generation wealth plan. And I think we don't need to worry about because we followed Maulana Haji Imam's guidance and prospered and accumulated the wealth. So I would ask each participants to think 10 years, 20 years, sometimes 30 and 40 years back and say, when we came to this country, what did we have? Many of us walked into this country with only a few dollars in, and look back and look at your condition now and see where you are now and where you were before, right? So then we saw that Maulana Haji Imam guided us, and with his guidance, we prospered, we accumulated wealth, and now what, right? So now he's guiding us to protect, to transfer this wealth to our future generation. Like Chairman Saab had laid out very clearly, we were Imam's firman, saying that what he said, what he told us, that what we don't need to worry about next generation, but generation after generations, because you know why? The reason is that 90% of the wealth, as Chairman Saab also alluded to it, that is usually lost between second and third generations. We think that we can leave money to our kids and then their kids, but not necessarily. I mean, our circumstances were different. As I said, you just look at your circumstances, where you were, where you are now. Our kids may be in a completely different circumstances. Today's condition in the world is completely different, and we see the wealth has been used differently. So this is not us only, and if you look some of the example, look at Elvis Presley, right? Prince, they had hundreds of millions of dollars of estate. They didn't plan. So what happened? They ended up paying millions and tens and 20 millions of dollars, I mean, 100 millions of dollars to, guess who? IRS, right? So this is why we really need to understand that what we need to do. So when we talk about this multi-generations, let's see, what does that mean, right? So what does multi-generation mean, right? So we had, like, our parents were born in 1920s, 20 to 45 probably, right? And then we were born between 46 to 1980, right? So we can see that we had a silent generation, which were our parents, and then baby boomers, and then the Generation X. And now we see our kids born from 1981 to 1996 and grandkids. So if you put yourself in one of these, then you will see that you can practically see more than 2 generations in front of you right now. Your parents or your grandkids, maybe if you have parents and grandkids, you're lucky enough, you will see 4 generations right in front of you, and you need to take care of them. So how do we do that? That's what we will today learn and do that, right? So asset protection. Andrea, we know that asset protection includes all these elements. Help us demystify these. What does that mean?
Well, there's asset protection in terms of, I mean, asset protection in general it's a broad term, but I think what's really relevant today and how I think about it when I'm working with families is, how do we think through protecting your assets so that they pass to your family? We maximize what passes to your family, what they inherit when you die, but also we do it in a way that is meaningful for your family in the way that you intend, and in a way that is consistent with your values and the values of your community. So asset protection it encompasses the estate planning, which we talked about earlier. It means, this is a great, actually, a graphic that kind of includes all of the elements. What if you are working and you become disabled? And having disability insurance protects your assets and your overall family wealth because it secures your income while you can't work. So too does long-term care insurance is critically important, as we are all, as different populations are aging and as medical care has gotten better and we are all living longer. That's a wonderful thing, but that also means that we have longer years to support and potentially greater medical needs. So, and we don't want our estate, what we want to benefit our family, to be unduly taxed by our medical needs. So having long-term care insurance is important. And then diversifying our assets, both from an investment side and an overall pool, to protect what we have in those assets, again, so that we maximize the benefit to our family. So when we think of asset protection, it's a multifaceted approach to make sure that and again, I think this graphic is lovely, because what it shows is that there are several component pieces that make asset protection meaningful.
Great. That's a good introduction. But we will go and we'll, as our program proceeds, we will see many other different scenarios that how we can do the asset protection. But these are all financials, right? So we see estate planning, disability insurance, and long-term care. But many people see that these are all the financials, but we also bring our values, right? We have values. So some of the values that our institutions and our communities guided by are the values by our development networks. So these are the values most of our participants are pretty familiar with. So could you please share that how can we incorporate our values in our estate planning also, and how we can add that into it?
I think you can in numerous ways. Number one, you can build in values such as compassion, sharing, sustainable environment. One way, but this is certainly not the only way, is through charitable planning and charitable giving. That's what many families do to make sure that those values are carried through generations, and that children, grandchildren see the family's commitment to those values, both during lifetime and over time through estate planning vehicles, I would say. I think many of these other values, such as self-reliance and governance, can be built into the trusts and wills themselves, in terms of how do we think about when children should receive distributions and why. You know, do we say, well, when you graduate from college, or when you do this wonderful thing, when you give back to the community, we are going to reward you with a larger distribution. That is one way that families accomplish that. In terms for respect for life and healthcare, being mindful and thoughtful in our healthcare documents that we'll talk about a bit later, in terms of making sure that wishes are known and respected. So it's, there are many ways to accomplish making sure that ethics and values are built in to an estate plan. What we find is often the challenge, but also the opportunity for families, is having those conversations during the planning process to make sure that the estate plan aligns with those values.
So that's interesting, right? So parents, when parents say that when they are gone, they're not just gone and leave their money, but they can leave their values with their kids. So even if when they are not there, the instrument that they create can continue to leave their presence to their kids and their next generation, saying, okay, what their parents and what the grandparents would have done with the money that they are still continuing to do.
Absolutely. And I think it's a multifaceted approach, in that some of this is accomplished with, conversations during lifetime. And that's a lot of the work that we do at Bernstein, in terms of helping families facilitate those conversations and doing it thoughtfully. It can be accomplished through creating a family mission statement, whereas, the mission statement itself is likely a sentence, but the work or two. So it's not a lengthy legal document per se, but the conversation and the work within the family to determine what that is something that will benefit multiple generations.
That's great.
So, yeah.
So go ahead, please, sorry.
So it's work that, and we'll probably talk about this towards the end of our conversation, but a lot of what estate planners, the work that they do is the how, in terms of how do we set up these documents, how do we accomplish that, all very important. But what's also just as important, I would submit even more, is the why. Why are we doing this, and what do we accomplish? What do we want to pass on to our children? And to your point, Abdul, that is our wealth for certain, but that's also our knowledge when it comes to our community and our, our business, our, what we have created. We want to make sure that our children and subsequent generations are equipped to take on those roles and those assets. But it's also the values. And I would say that's actually really the most important thing. And that goes to the essential why. This is why we have created this wealth. And we want you to be aware of that. So as you take on the mantle of managing this wealth, and as you steward it for future generations, you understand it and you protect it. And when I say protect it, it's not just the wealth. We want you to protect and put forward these values.
Great. So any parents, like for example, they are worried about whether their kids are going to continue their college, or maybe they're not financial savvy, they can use these estate planning tools and instruments to actually continue to instill these values in their future generations while providing support, financial support for them. That's
Absolutely.
great.
Absolutely.
Okay. So let's get started. So the question is, okay, what does financial planning entail, right? So what are these steps that people who just getting into the financial planning or estate planning, what do they need? So what we think that there are about 5 steps. If people in this particular webinar, if they can just remember these 5 steps and one critical deadline, will accomplish a lot, right? So the first is the inventory, right? So we need to inventory every single thing. What do you have, right? All the assets, including your partnerships, your other assets, and everything that you have. Just inventory everything. Then determine the type of ownership. Like, so many people have partnerships in different organizations. Some have handshake agreements. Some joint ownership of some assets and things like that. So that is going to go differently, and we'll go down the webinar and explain how does that work. Then they need to classify the assets into distribution. Like, how can we transfer these assets? Some can be transferred using the will, some cannot be transferred using the will. Some can be transferred using a combination of both as part of estate planning. Then this is the key element, right? So people need to determine, or our participants need to determine that we need to determine that what does our family need? Who needs what? And why do they need it, right? And the question is, okay, so what are we going to leave behind? Are we going to just leave behind a big chunk of money for our generation? Or are we going to leave behind some value with that big chunk of money, or for this generation or the next generations, or moving forward multi-generations? Then the fifth step is that once we have done the inventory, once we determine the ownership, once we've classified the assets, saying which assets are going to go how, and then we determine who needs what and why, then pick a right plan working with the professionals like you, like Andrea, and determine exactly how are we going to accomplish that we need to accomplish, right? So with these 5 steps, so help us how these two, like you try to, blend these two together in your previous, but just help us saying, okay, how these assets can be combined together in transferring into the wealth.
Well, I would say, like, for example, when we're talking about financial assets and we're determining, or actually, you know what, I'm going to use another asset in terms of a business. Often we want our children and grandchildren, we want subsequent generations to take over that business. We've built this business and we want our family to benefit. But we need to make sure that they have the tools to do that, that they have the knowledge of the business specifically, that they have knowledge of business skills generally to do that. And so I've seen estate plans that build in stipends for children to get business education. So that's one, I think, elegant way of marrying our values and our goals for our family with the assets that we have, that will pass to them.
That is very interesting, actually, the example you just gave. So not only you leaving your business, but you also conditioning it with the learning of the business before the business gets transferred to anybody. That's very interesting.
It is, because, and that's a lot of the conversations that we have is with families, especially with business owners, is to make sure that the part of the shirt sleeves to shirt sleeves phenomenon that we've been talking about, not always, but part of it comes with you know, a knowledge gap. And so what we found is making sure that these subsequent generations are equipped to handle the business, both the knowledge of it specifically, but also just having the business acumen to run a business, goes a long way in making sure that you know, the shirt sleeves phenomena doesn't occur. So it does go back to what we've been talking about, of making sure that the values are passed along with the physical assets. There's definitely a need to marry those to make sure that, and also make sure that there's a match between the generations and what's being passed.
Actually, this gives a good comfort to those who actually own businesses and they have children they believe may not be ready to take over the business. So this gives them good comfort, saying, okay, not only they can transfer the business, but also enable them to run this business as successful as they have done, or even better. That's great. So we'd like to do a small poll. So please, participants, please take a few moments and answer this question. This is anonymous, so you don't worry about nobody is identifying anyone. Okay, so we can now move on. So Andrea, this is the key now. Okay, so we said estate planning directed by our ethical value includes, you alluded to these in one of your earlier introduction, that this includes all. Now let's go through this individual and then see, why do we need this as part of the estate plan? And then what does it do in completing the estate plan?
Sure. Well, I think as a preliminary comment, I think it bears reminding that not every estate plan will have all of these components. And part of the work that you do with an estate planner is determine what you need, and so that it's customized to you and your family. These are all very common though. And so it, going around the slide, I think the first one that most folks are likely familiar with is a will. And a will is a document that that is drafted that provides for how your estate will be distributed when you pass away. And it names executors who are the managers of that process, who help shepherd those assets during the period when things are being administered, and then oversee the distribution. Wills also in many states have a very important function of nominating guardians when you have minor children. So wills are very important. Wills are often paired though with the next item on the slide, if we're going counterclockwise, with trusts. And trusts are a bit different in that you don't necessarily need to have a trust with a will. But what a trust does is it's an agreement where you, an individual, give an asset to a trustee to manage it for the benefit of a beneficiary. When you're alive, often that trustee is also you. So if I had the Andrea Kushner Trust, I would be what we call the settlor or the grantor. I'd also be the trustee, so I'd manage it for myself. What a trust does, though, is it provides instructions of how assets titled in the name of that trust are managed if I become incapacitated. And then it also provides instructions for how things should be distributed when I pass away. And trusts and wills in that third element can have often have provisions that deal with estate tax and tax planning. There are certain exclusions and deductions that we have available to us, especially when you're married. and with wills and trusts, when they're properly drafted, can help use those in the most efficient way. So that is can be a big part of the planning too, but that's not the only reason. In fact, I would submit the bigger reason that you want to have a will or a will and a trust is to make sure that things are distributed as you intend and consistent with your values. Charitable planning can be a large part of estate planning, and that can come in various forms. Often a will or a trust can include charitable beneficiaries along with family members. You can also make charitable gifts to your lifetime, and there's certain specified charitable types of trusts that you can create either during your lifetime or at your death as well. Succession planning, I think, is a critical one, and one I'm glad to see is on this list, and a key one for business owners, because often you need additional documents to make sure that your business interests are distributed, managed appropriately if something happens to you, if you become incapacitated, and then also at your death. And by those, I'm talking about things like shareholders agreements, partnership agreements that talk about, what happens at various phases of a partnership. Also buy-sell agreements, when someone wants to leave a business. All of those types of things are part of an integrated estate plan when you have a business. Living will is another one where, I'm going to use the broader term, where it's a healthcare power of attorney, or in California where I live, it's called an advanced healthcare directive. They're basically documents that give someone the ability to make medical decisions for you if you become incapacitated, and then also set forth what types of medical care can be provided. Sometimes you have separate documents, in other words, a living will that talks about the medical care, and the healthcare power of attorney that names the agents. In other states like mine, it's all in one document, but also a very critical part of an estate plan. Life insurance is one, and long-term care. We talked about this earlier, but life insurance is a key part of estate planning, to make sure that there are sufficient assets to pay for expenses, estate tax upon occasion, business debt, other business expenses if someone passes away. And then finally, the marital deduction. The marital deduction is a concept where anything that passes to a spouse is not subject to any estate tax when someone passes away. When you're married, any tax that is due when planned appropriately with the marital deduction, any tax that's due waits until the second spouse dies. And so proper planning with a will and a trust can help maximize the use of that. And then one last comment that I wanted to make is that with respect to trust, there are two types of trust, two categories, if you will. One is called a revocable trust, which means you can change it or modify it at any time. And with estate planning, with what I would call basic estate planning, that's what we see. You want to be able to change it over time as your wealth changes, as your family expands, as your business interests grow. It's something that should grow with you and be able to be modified. That's different than what we'd call an irrevocable trust, which is a trust that isn't changeable after it's put in place. That's often what we use when we're looking at more advanced planning, when we're trying to shift assets off our balance sheet to grow for the benefit of our heirs. Those are because gifts to those types of trust shift our assets off our balance sheet and make for very effective tax planning. So
this is good. People do understand planning includes financial assets, but to have living will and funeral arrangements and life insurance, it's not as common understanding that would be part of the estate planning, but this is great. But we'll move on and we'll see, okay, so now you talked about the wills and trusts, like what are the differences that you can transfer? So here's some of the comparisons. So could you quickly elaborate on this one, that why someone who thinks that they can have a will and they can have an LLC, they can transfer their LLC to their kids or whoever they want to, and then versus what the trust can do?
Sure. Well, I think there is having a will is a document that doesn't come into effect until you pass away. A trust is a document that once it's signed and it's funded, meaning assets are transferred into the name of that trust, is a living arrangement while you're during your lifetime. And that's important for many reasons. Having a trust largely avoids the probate process, which is a court supervised process when someone passes away to change the title of assets in their name to the ownership of beneficiaries. Having a trust largely can avoid that. A will doesn't necessarily avoid that process. It depends on, in certain states, mine being one of them, if you have a modest size estate, which is about less than $150,000, you can avoid the probate process if you have a will. But above that, you can't. And so what that means is that the court still oversees the process of changing those assets to the names of living people, even with a will. Probate, there's different experiences among states, but that can be a time-consuming process, and it can be expensive, and it can delay distribution to beneficiaries. So it's not necessarily, it's better to have a will than to have nothing in place, because at least with a will, you are determining how your assets are being distributed. If you don't have a will, then it's determined by state law, and that may not be what you intend. And actually, use the Prince example earlier. Prince was actually a very charitably minded man, but charity is not a permissible beneficiary under the laws of what we call intestate succession, when the state statutes determine a distribution. So it's likely that the way that his estate is going to be distributed may not be what he would have wanted during his lifetime. So he would have been better at, he should have had much more integrated planning, but at a minimum, a will would have helped him there.
Great.
Taxes, you can do some tax planning with wills and with trusts, but I would say the fees, when it goes through the probate process, even with a will, can be kind of significant, and you avoid that with a trust in most states. We kind of got into the access and control issues in my earlier comments when it comes to wills and trusts, so I'll go through that. But I think the last point is one that's critical, is privacy. With a trust, you can avoid the probate process, and your assets are distributed privately as you intend. With a will, if your estate is subject to probate, it's subject to public inspection. And so things are filed with the court, and so your family's assets and who the beneficiaries of your estate are subject to public record. And that's not, if privacy is something that's important to you and your family, that's another reason why getting your estate in order is really important.
So you mentioned the marital deduction. So the entire, I would say, the key urgency for having the estate plan now is this. Please help us understand why this is so important to do it today, or at least now.
Well, we're at a interesting, so the estate tax exclusion is the amount that an individual in the US can pass either during their life or at death or anything in between without triggering estate tax. And that exclusion, that amount, is historically high. It's 11.58 million per person. So if you're married, it's over 23 million that you can pass without triggering any sort of estate tax. If you go above that threshold, the remaining estate bears basically a flat tax of 40%. So it's a significant tax. However, that's the law as it stands right now. The law is scheduled to sunset at the end of 2025, and the prior law, the prior exclusion, is set to come back. And that exclusion, with inflation adjustments, would be approximately 6.5 million per person. So that would be 13 million combined with a couple. Still very high, historically speaking, but certainly not as favorable as it is right now. There's definitely urgency to act right now, given the fact that the laws may change and we're not sure where those changes could land, and we're also not sure when those changes could go into place. There is authority, constitutional authority, that tax changes made next year could be potentially made retroactive to January.
Okay. So in my previous slides, when I said 5 steps and 1 critical date, so the key critical date for participants is December 31st, 2020, right? So anyone who believes their assets are $3 million or will go to above $3 million, they need to worry today and have their plans done by December 31st, 2020. Is that correct?
I think so, or at least reach out to estate planners and start having those conversations. The feedback that we're getting across the country is that because of these looming changes where we're uncertain where the exclusions will fall, a lot of people are getting their estate plans reviewed and redone, which is fabulous. But it also means that planners are busier than they've been in recent time. And so it's important to reach out now while you can to make sure that you can have those conversations and do this work thoughtfully.
Let's put this into perspective, right? So here's an example. Like someone has probably gross estate of about $7 million today, right? And so currently we have an exclusion $11.5 million. So please walk us through this scenario and say what will be the estate. Let's say if we go into the worst case scenario where it goes down to $3.5 to maybe even $6.5 million, depending on how the politics work out next year. So what will be the implication on individual who has $7 million today, or at least total combined, the gross estate with husband and wife?
I think, today, if the exclusion remains as it is, someone with $7 million estate planning, tax, or planning for the estate tax, although important to be mindful of, is likely not going to be the driving consideration, because right now you're below the thresholds. However, as you can see on this page, if the estate tax exclusion is reduced, a $7 million estate, if you're married, if you're married, you'd have 3.5 each spouse, or 7 million combined. So it really depends on how your estate grows over time and where those exclusions fall. With a $7 million estate next year, you may have an issue, you may not, but it's still a good idea to have your planning looked at. It's really in the future as your estate grows where you need to be concerned. And that's where, because, in some of these examples, like in 2031, for example, if your estate grew to 14 million, but the exclusions were 3.5 million, then you could have 7 million of your estate subject to estate tax at a 40% rate or 45% rate. So that's significant. So I think the call to action here is really, no matter your wealth level, it's important to have your estate plan be reviewed, or if you don't have one, put into place. But it may be, because the exclusions are in flux, your estate plan may need to have some estate tax planning included in it, or some flexible planning, so that in the future, if the exclusions are reduced while your wealth grows, you've planned for it and your estate isn't caught by surprise.
Great. So unless someone feels very generous to share their money with IRS, they really need to plan by December 31st, 2020.
Absolutely.
Okay.
Absolutely.
So now this number some people may think, I don't have this much money, right? So let's go through some scenarios where even like very small amount of money is going to make a big difference for estate planning, right? So let's start with an example. Let's say we have a husband-wife, Salim and Zara. They have 2 kids, $2 million, and not big estate, right? And then some underwritten partnership investment, right? And so which Salim and Zara together, they have a home, a business, some life insurance, jewelry, and some liabilities. Okay, right? So we take all this into consideration, and then so total net worth is about $2 million, or maybe a little more than $2 million. They have a will, and they have some underwritten partnerships. let's go through some scenarios and see what happens to this family, right? So let's say in event one person passes away. So what are the consequences with just a will and no estate plan and unwritten partnerships?
Well, what could come to pass is in most states when you're married, there are expedited procedures to pass assets from to the surviving spouse, and it's likely the wills in place would do that. But it would not necessarily be a streamlined process, and especially with unwritten partnerships, it would, there's the potential for a lack of clarity and disputes when it comes to the surviving spouse, especially if the surviving spouse wasn't involved in the management of that partnership. That could definitely get sticky. So number one, I would recommend to this family to say, look, this unwritten partnership, let's get something in writing so it's clear what your interests are and what the obligations are for the partners and what happens if a partner passes away. So that I think is critical. And then, bear in mind when one spouse passes away, especially when you have, at any point, but especially if they're young children that need to be cared for, it can be a very traumatic time. And so you want to make that as easy as possible for the surviving spouse to be able to take care of themselves and the family and kind of rebuild after that. So I would recommend to this family, they look at actually having a trust so that for the assets, so that it provides more streamlined distribution. It also provides more privacy and likely quicker access to the assets for the surviving spouse to care for their needs. So they're not waiting for the probate court to confirm things and give access to accounts and things.
So Andrea, remember law school when you thought you answer all the questions and the professor changes scenario on you? Here you go. So now both are gone. Both parents are gone.
Okay. So a lot of what I said is true, but now we have the additional consideration of we don't know from the facts presented whether guardians have been named in the wills for the minor children. I hope they have. But if they haven't, that could be a difficult process, because that means on top of distributing, getting things in order for the minor kids, we've also got to go to court and name guardians to care for them. And it's not, guardianships come in two forms. There's the guardianship of the person who's actually going to care for the children. And then there's a guardianship of the estate who's going to handle the finances for the children when they, while they're minors. Often if provisions in wills aren't clear on that, what occurs is that children whose assets are put into guardianships while they're young, they're entitled to inherit them in many states when they turn 18. And so this is another reason why thoughtful planning is important, because I would say most families with whom I work wouldn't want 18-year-old children to have access to any sort of significant wealth. Not that there's anything wrong with 18-year-olds, but they not historically, they haven't fully developed as people or their financial acumen. So we want to give them a little more time so that they can come into those assets. And it goes back to the education that we were talking about earlier. We want them to be of sufficient age so they can manage what is in front of them.
So this actually brings up an interesting point. Then $2 million doesn't make any difference, right? If you have even a smaller amount of assets, right? And then you have minor kids or kids that need help, then the dollar amount doesn't make any difference. You need to plan now for that regardless.
Absolutely. The question I often get is, my estate is X amount, do I need an estate plan? And my answer is always yes. And it doesn't matter what that dollar amount is. What it may affect is what your estate plan looks like.
Okay. So let's make it a little more complicated and bring it more close to home. Many people do have living with their parents. They have some elderly who are receiving the Medicaid or other government benefits. And some may have some special needs children, or maybe have some disability in the house, right? And then both parents pass away or one of them pass away. So how do you address these issues in estate planning?
Well, I think especially if you've got family members who are either receiving government benefits or could be potentially eligible to see government benefits, how assets are held for them is critically important. Because if you are someone with special needs and you have significant assets in your own name, or it doesn't actually even have to be that significant. Once you cross a certain threshold in many states, you become ineligible to receive certain benefits. And so there are ways in trusts where they're called special needs trusts, where assets can be set aside where they are available to supplement other benefits, but they don't take the place of them. And so they require special planning and special drafting to make sure that those assets are available, but it doesn't disqualify your loved one from qualifying for the benefits that they need.
So in this case, even if you don't have any money, if you have like $3,000 and leaving $3,000 your parents, that's going to disqualify them, right?
Yeah,
so,
it can, yeah.
Right. So
and
you need to, sorry.
Oh, definitely. And we've seen it on the other end of the spectrum of very high net worth families who say, well, we have sufficient assets. We don't need to worry about those benefits. So we're not going to put those provisions in. The problem is there on the other side, there's certain therapies and certain programs where you're not eligible to apply unless you are eligible to receive government benefits. So you could inadvertently disqualify your loved one from a therapy or a program that could be helpful for them by not being thoughtful of how assets are held for them.
This is great. So yeah, I think this is really an eye-opening for me also, that how do you take care of your loved ones? Even if you leave few $1,000s, that can disqualify them from all the government benefits. Yeah. So let's make it a little more complicated for you. How about it's a complex family structure. We have now stepchildren, step-parents, non-traditional families. Does estate planning become more important, critical for them? And why?
I would say definitely, and it goes in both directions on the spectrum. I've worked with many families that are considered blended families where they're stepchildren, but they consider themselves each other 100% family and would want each other to benefit from their estate plan. But under state law, if you don't have an estate plan, you pass away, your stepchildren, for example, may not qualify under the lines of succession if you don't have an estate plan. So that's one area where if you want stepchildren, or you have more of a non-traditional family or friends who are family, and where you would want them to benefit from your estate plan, that is all the more reason to have a detailed estate plan naming them as beneficiaries with specific distribution provisions so that you make sure that they will in fact benefit. On the other side of the spectrum, I've seen conflict and strife after you have a couple who is married, one of them passes away, and the children of the person who has passed away are now in conflict with the surviving spouse of the marriage. And it could be, that surviving spouse be living in a home, for their lifetime, or, there could be provisions, but without very clear instructions of what they're entitled to do and what they're not entitled to do. It can really, it can make life difficult on both sides.
So one thing what I have seen is that some of the states like Florida, if one parent's passed away and has some kids from previous marriage, and then they got married to another person, they think that if they don't have will or anything, they can leave everything to their spouse. But the intestacy law requires that if have one child from another marriage, the spousal share becomes significantly less. And many people don't realize that they really need to think through about this one. So This is great.
Absolutely.
So now, sorry, go ahead.
No. I was agreeing with you.
Yeah. So next question comes a lot. And I think some of the questions that we just saw right now also addresses that. It's about business people, right? So they have businesses in multi-states. Right now, our example includes that, okay, they have LLCs, they have income coming out from different states. For example, they have a convenience store in Texas, they have another convenience store in maybe Louisiana, and their income's coming from there. That's one example. The other one is, what if they own some properties, rental properties, or some other businesses, let's say in Pakistan or Canada or India or someplace, right? So how does that work when in terms of estate planning? How do you address those issues?
I think that's another, especially when you have properties or real estate or business interests in different states. That's another area where it's critical that you have an estate plan in place. If you don't, the potential is not only may your heirs have to go through the probate process to get those assets transferred, but they're going to have to go through the probate process in every state where those interests are located. And that actually happened to a family with whom I worked when I was in private practice. Dad was not a fan of funding his trust with his real estate as recommended by his estate planner. And so when he passed away, I was one of 14 attorneys in 14 different states who had to work with the executor based in Georgia to get everything transferred. And so we got it accomplished, but in that, the family bore a lot of attorney's fees and costs in all of those different states, and it really delayed the distribution because it wasn't handled thoughtfully while he was alive. So that's definitely an area where you want to have good planning. There's an added complexity when you have property in different countries, either real estate or business interests. And in those cases, it's critical to work with counsel in those countries to make sure that, because the laws may not be the same as the US. And so to make sure that your estate plan here is coordinated with that is very important. And so I would say when you are meeting with your estate planner to go through all of your assets and to determine what estate plan is appropriate for you, making sure that you're very thorough with all of your assets, and make sure that you include everything, even things that are in other countries, because it may be that your estate planner in Texas isn't equipped to deal with property that's in France, but will help you get an attorney in France to make sure that those interests are dealt with in the right way.
Great. So many people think that they have all the businesses in different states and they leave lots of money, but in the end, most of the money goes into legal costs and legal fees.
Exactly.
And so that's interesting. So let's go to some different example where these Salim and Zora are professionals, right? So they have some kind of profession, they're working in their profession. So they don't have traditional businesses, but they have like stock options, some vested, some unvested, some investment, typical retirement accounts and basic. So do you see this scenario any different than the one that we already discussed in terms of estate planning?
No, but I would mention two things that are key here to think through. Often the good news is, like, for example, if you have unvested options, typically they will become vested when someone passes away. You'd have to look at your company's documents, the issuer, to see what the rules are. And most plans will allow the executor of the will or the successor trustee of the trust to exercise them. So to avoid delay in doing that or being able to do that, having your estate plan in order so that there are people designated to act on behalf of your estate when you pass away, that's really important. The other thing to bear in mind with options is when they are, depending on the type of options, when they're exercised, if they were offered as compensation, that triggers ordinary income. And so making sure that there's sufficient liquidity within the estate to pay for any income tax that may be triggered as things are getting sorted through and options are being exercised that's important. So I would say in those cases, we're fans of life insurance for all manner of situations, but this is another one where having life insurance would be very helpful because it would provide a pool of liquidity to help manage that so that it didn't become a burden on the surviving spouse.
Okay. So now we've gone through some scenarios which most of the people will be able to relate to it. So now comes the planning. So walk us through what can we do and how these things can be transferred.
Sure. Well, this kind of goes back to some of the conversations, Abdul, we were having at the beginning of our remarks, which is, what are the things that you can transfer to your family? And there are really three things. And we work at the intersection of those things, but it's your wealth, your values, and your knowledge. And in our view, good planning involves addressing all of those to make sure that the way that you transfer your wealth includes your values, but also arms your family with the knowledge so that they can manage that wealth and steward that wealth in a thoughtful way, and making sure they're doing it in such a way that it allows your family legacy to continue over time.
So how do you engage? Yeah.
How do we engage? We do it in a variety of ways. I mean, I think it requires communication within the family. And I think that especially when you're the founder, when you're the wealth creator and you've created this wealth, you want to share it with your children. But there's also, I think that, at least I've seen, I would love your thoughts on this, Abdul, with what you've seen. But I think that there's sometimes a reluctance to be fully transparent about the wealth that has been created in terms of the amount and what it looks like, because of a fear that it will quash the self-reliance and the work ethic of kids in subsequent generations. How do we create an environment and pass on our values so that our family benefits from our wealth, but that wealth isn't used in a way that it squashes their work ethic and their desire and drive to do better in the world. And so what we have seen that addresses that is really just communicating what are those values, what are your concerns, what are your goals as a family. And so we do a lot in terms of facilitating family meetings to have those conversations. We also have quite a bit of exercises because sometimes we know what the overarching goals are and we know what our values as a community are, but kind of drilling down and figuring out what our personal goals are, what our family goals sometimes can be challenging. And it's hard to communicate if we don't have a handle on what those goals and values are. It becomes harder to communicate those down to our family. So we have quite a few exercises that we employ around what are messages around money that we have heard and what do we want to pass on to our children. We have some great things where we use values cards and have families identify what are your top 5 values and why. And it's fascinating to do this with parents and children because the values actually, it tends to be more similar than you might think, but it's where the differences come in really gets a lot of communication and thought. And what it usually occurs is that there aren't really such differences. It's often in how you view a situation or how you define the words. So we use those exercises, and then from there, it really depends on the family and what they are looking to achieve and what they're looking to do going forward. At the bottom of this page, you see we work a lot with families to create mission statements and vision statements, where we do this in our businesses often, but we don't often do it as often with our families. And I'd submit that's even more important within your family, to make sure that it goes back to how do I define my goals so that I can transmit them and communicate them to my family? And then
this is interesting. Yeah. This is sorry. I'm sorry.
Please.
I wanted to make sure that they emphasize the communication aspect of it, because even now, like even if you don't have estate planning, parents want kids to do something. I want you to be a doctor. I want you to be a lawyer. I want you to do this and that, right? And So kids do come and talk. I have no interest in becoming a doctor, but I could be a good engineer, I could be a lawyer, or whatever that may be, right? So many times it gives them some surprises, but when you leave a state plan without communicating with your family, and then your state plan requires that your child must graduate from a medical school, the child has absolutely zero interest. Now that child, you left that child with resources that they could have had, and now they're going to sit there and wonder, why didn't my parents do this to me?
Right. Yeah. I mean, I think it's a great point. And it's important to step back and help define as a family. Like, it sounds like in that family, success would have had a very narrow definition. To be successful, you must be a doctor. If you are not a doctor, you are not successful. Right. That sounds like that's the message. And I think in most family, you kind of stepping back and saying, well, is that really consistent with our values as a family and a community? If our values as a community is to support the community and have a fruitful life and, support charitable causes and do good in the world, is being a doctor the only way to accomplish that? So those are the types of things where I love that example. And I'm glad that you raised that, because I think it's one where that's a family where, honestly, I think we could really help them if they had come to meet with us and say, well, okay, let's step back a second. And why is that? Let's really think through what the family definition of success is, and what are all the ways that someone can contribute to the world. Is being a physician the only one? By the way, I'm a huge fan of physicians. My dad is one, but still, there are many ways to be a productive citizen.
Absolutely, yeah. So communication is really important.
Yeah.
Before you plan your do the estate planning, you really need to sit down and say what exactly you want to do, what legacy you want to leave. So everybody is on the same page, understand, right. This is what my parents want, and they all get along with that. So these are the resources that you may want to just quickly go through that. And
oh, sure. This is we've talked often about making sure that children and subsequent generations have the tools needed to steward the family wealth, or the family business, or the family enterprise, whatever, or the family's charitable arm, whatever that is. We want to make sure that our family is equipped to take on and steward the wealth that is being left to them. And so we do a lot in the way of education at Bernstein to help with financial literacy and investing. And so any topic on this list, and I promise everyone on the call, we're not going to inventory them, but my point is, we have a very detailed library of what we can cover and how we can be helpful in the education process. And these are all topics that we speak and write on a regular basis.
So how does it all begin?
Well, I mean, I think what you see, it kind of goes back to the conversation that we had in the beginning. As Bernstein, we are an investment manager and we invest financial assets, but really, when you talk about that part of the planning, that's actually, those conversations are fairly, not late, but that's not the first conversation. That's fairly, where it starts is really with goals and values and what you want, making sure, and the planning, and making sure that that someone's financial plan and estate plan is in order and is consistent with their values and what they want to achieve. And then we match the investments to that plan. So it goes back to the values and everything that we talked about at the beginning. And it also goes back to our, the call to action that we talked about at the beginning of this call and have throughout, which is estate planning is critically important. Everyone should have one in place. And given the changes that are facing us, making sure that you speak with an estate planner and get things in place by the end of this year, very important.
So that's great. Thank you very much. It was a great learning for myself also. So if I can reemphasize one thing, is like the amount of assets do not matter, but your family situation does. Regardless, that we saw in the case of seniors, even $3,000 make a big difference if you leave to your parents. And the second thing is that those who have some asset like around $3.5 million or so. For them, the critical deadline is December 31st, 2020. They must have a state plan completed by then. Is that correct? So
I think definitely yeah, I think for everyone right now, given the tax changes and also the health crisis that's facing our country too, at all wealth levels, it's critically important. But yes, I would agree with you, given that the exclusions could be as low as $3.5 million. It's important to speak with an estate planner right now and get your planning in order.
great. Thank you very much, Andrea. So for our participants, what to expect next, right? So the key is they really need to take some time out, and then the time, the critical time, as we just discussed, that the time is the essence of right now, right? Time is of essence, because we need to make sure that everything, all the plan gets done before the end of this year for those who may get hit with the state tax, higher state tax. Planning is key. Family involvement, we could not emphasize more on family involvement and the communication. The key professionals, they really need to identify. We do have, EPB is going to share this information with everyone in a minute, that we do have all the resources available for all the participants. And the cost, I mean, you need to understand that it's going to involve some cost. And we'll talk about this because there are some questions already come in about this one, and we'll discuss it in our Q&A. I could not and I cannot reemphasize this periodic review and management, because even if I do will seminar, even for wills, many people say, and recently, about a couple of weeks ago, somebody asked, oh, I have a will, but that's a 10 years old will. It doesn't matter. Like, no, it does matter. Will does not die. It does not expire. So you really need to have a plan for periodic review. Like they do, they review their assets list, right? They review their financial plans and everything. You review your balance sheet. Same way, you need to have a periodic review. Of course, the professionals are going to set up some review time with you and then figure things out to make sure the plan that put together is still valid and goes with that. So with that, I hand it off to Rosemary.
Thank you, Abdul Rasul and Andrea, for an amazing presentation. But before we proceed to the Q&A, let me share a few points with the participants. We have created an MWMP resource page, which is at ismailichambers.org/MWMP, where you can access the wealth estimation worksheet and a list of attorneys. It's an initial list, and if you want to take a screenshot, or you can copy it from the link from the chat window. And to summarize, today we covered the benefits of estate planning and who should have it. And now we want to urge the participants to take the following steps. First, discuss with your family if they're ready to start an estate plan. Second, complete the wealth estimation worksheet. You will need this when you start working with your attorney. And finally, reach out to an attorney. Now, if you need additional help from the MWMP team, please use the link that is shared on the screen to contact us. We will be sharing the recording of today's webinar, and I hope you will share this with other families that weren't able to join us today. Make it a goal to establish an estate plan in 2020. As you're aware, the elections are right around the corner, and remember, your vote counts. Now back to Abdul and Andrea to address some of the questions.
Great, thank you, Rosemary. So Andrea, I just got one question, which I think we already addressed it, but we can just reemphasize it, is that what about the properties in different states, in different countries? So if I recall correctly, you said that once you have a planner, they will work with the appropriate professionals in those states to bring all of them into your estate plan, correct?
That's correct.
Yeah, so another question is that, can we just transfer asset using simple LLC, or do we need to have an irrevocable trust, considering the state tax? What will be the implication of state tax in that case?
Well, bear in mind, an LLC and an irrevocable trust, both are great planning vehicles, but they do different things. So an LLC is a business entity. It provides some creditor protection. It provides some ease of management, but it's an LLC without any further planning is on your balance sheet when you pass away. So it's included as part of your taxable estate if you are of, you know, the wealth levels that we talked about before. An irrevocable trust is one. It's considered a separate entity. It's a separate taxable entity. It is separate from you. So once you make a transfer to an irrevocable trust, you've made a completed gift in most cases, which means you don't own that asset anymore, and the irrevocable trust does. And the reason for that planning is actually business owners do this quite a bit. If you have an emerging business and you make some gifts of small business interest to the irrevocable trust. So now the trust becomes a shareholder and you're the shareholder. The business grows in value now, which is what we expect. Then the growth that happens inside that irrevocable trust happens off your balance sheet, but for the benefit of your beneficiaries.
So next question is that, do you need to appoint only one person in terms of you're managing your estate, or you can have a group of people or multiple people? And what are the pros and cons?
Oh, that's a great question. I really like that question. And the answer to that is I would recommend that you name at least two people as the trustees or executors, the primary and an alternate in case something happens. You can name multiple people so you can have co-trustees, you can have or co-executors. So you could have two people acting at the same time, or three people. I think you need to do that thoughtfully, because when you have two people, what if they don't agree? You don't want to create a situation of deadlock where decisions can't be made in an estate. There are ways to get around that. You could give one of them veto authority, or you could name another person as the tiebreaker. But so there are ways that you can deal with that in a plan. You also want to be thoughtful about who you name in those capacities if you're going to have co-trustees. If it's your brother and your sister who have never gotten along and you put them as the co-executors of the co-trustees, and I'm laughing because I actually had clients who tried to do this.
It happens all the time.
It happens all the time. And it's like, okay, well, let's, if they've never gotten, we know they love each other, but if they've never gotten along, let's think about how this is going to go in practice. Maybe naming them both in that capacity isn't wise.
So next question is that most of our community members are in retail business, like for example, a gas station, Dunkin' Donuts, jewelry, etc. And they have kids who are young, they go to college and they are now educated and professionals, and they probably would not want to take over a Dunkin' Donuts or gas stations or something like that. So in that case, how do we transfer business asset? What do we do with that to ensure that they continue to have benefits for their kids and their next generation, but yet still can transfer the assets without having any complications?
Well, I think this is one of the areas where communication is key, and having communication with the children and their expectations and their desires. Because I've often seen in businesses where I've seen it go both ways, where mom and dad think, oh, in a million years, the kids won't want to take the mantle of this business, and so we'll sell it when we retire, and they'll get the cash proceeds, only to find that the children were really upset because they watched mom and dad grow this business and they really wanted the opportunity to take it to the next level or to be a part of it. And mom and dad just assumed that they didn't want it. On the flip side, I've seen what you've discussed, which is mom and dad work very hard with the idea that children will come in and work in the business and be really involved, and the kids aren't interested. So I think having a communication regarding expectations and a thoughtful succession plan is critical. And also thinking through, if the kids do want it, then making sure, or meaning they want to be involved, making sure that they have the training to do that. In the example of the Dunkin' Donuts or the retail businesses, if a child is a microbiologist, They're highly educated, but they may not have the business skills necessary to run that franchise or to those, that conglomeration of businesses. So that's one. Going back to that, I would say the other consideration is in the succession planning, thinking through what does succession planning mean? Does that mean selling the business at a certain point? Does that mean transferring interest to children over time or at death? How does that look like, and how we do it in an orderly way that we maximize the value for our family?
So next question is, when the state tax law changes, does that affect previously set up wills and trusts? Now, I think that's probably more relates to whether you're a revocable trust or irrevocable trust. So can you please address that issue?
It may, because, and so all the more reason if we typically recommend that you review an estate plan every couple of years. That doesn't mean it gets changed every a couple of years, but make sure you look at it every couple of years to make sure that the trustee and executor designation still makes sense, the guardianship provision still makes sense, the distribution provisions. But it could be, if there is a significant change to the estate tax laws, often planning is done within these documents based on the formulas that are keyed to the estate tax. So if that changes, the documents may need to be changed. So I would say all the more reason, given that these changes are on the horizon, to go see an estate planner, because it may be that things can be built into your documents to make them more flexible on the other side, so that all of a sudden, a change in the law happens in January, and now we're sitting with documents that don't make sense.
Just last question. Special need trust for special children.
Yes.
Could you say a little more, elaborate those?
Sure. So a special needs trust is one. There are actually two types of special needs trusts. There's what we call a first party special needs trust. So let's say a child was in a horrible accident and received a big settlement, like a court settlement. Those funds, are put into a trust for that child's benefit. So they were owned by the child, but they're put in this irrevocable trust for the child's benefit, so that they're managed appropriately, and so the child can still qualify for benefits. That's different than the type of trust we see a lot with our clients, which is what's called a third party special needs trust, which is one where typically parents or grandparents put assets in a trust to be available for a child over time. The idea with these types of trusts, though, the theme is the same, and that's, we want these assets available to supplement things that the government doesn't provide, but we do it in such a way so that it doesn't disqualify the child from receiving benefits that they need from the government. Because to your point, Abdul, the thresholds where children who need special services, the asset thresholds are incredibly low. And so this is a way sanctioned by the government, and every state is a little bit different. But the idea is, how do we set these funds aside so that these kids still get the government benefits that they need, but still have access to family wealth to provide for extra care?
Andrea, thank you very much. I could not emphasize, this was a great learning experience for myself also. And you share your knowledge. So with that, I hand it off to Rosemeen.
Thank you, Abdul Anand. With that, I want to thank all the participants. There will be an email sent with the survey link, along with all the important links that we shared today. So please do fill out the survey. And with that, thank you very much for attending. Stay safe, and Yalimdad.